This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today I'd like to speak about why a 5-year lease on a Mercedes-Benz is not a temporary automobile, and why a lawyer should never sue an insurer when there is obviously no coverage. This case involved an insurance dispute in which Benjamin G. Dusing alleged that a 2016 leased Mercedes was properly insured by the Metropolitan Property and Casualty Insurance Company. Metropolitan disclaimed coverage for the vehicle, which was destroyed by fire on June 25, 2016. In the lawsuit, Benjamin G. Dusing versus Metropolitan Property Insurance Company, an August 26, 2022 decision of the Court of Appeals of Kentucky, Dusing claimed he was driving the vehicle at the time it caught fire. As of Metropolitan's refusal to pay Dusing, he sued for declaratory judgment in Kenton Circuit Court on June 21, 2017. The court subsequently granted what is styled as Metropolitan's motion for judgment on the basis that there was no coverage pursuant to the terms of the insurance policy with Metropolitan. A motion for summary judgment, of course, should be granted if the pleadings, depositions, answers to interrogatories, stipulations, and admissions on file, together with the affidavits, if any, show that there is no genuine issue as to any material fact, and that the moving party is entitled to a judgment as a matter of law. The policy at issue provided the following relevant terms, quote, "We will pay for loss to your covered automobile or to a non-owned automobile, including its equipment not caused by collision, minus any applicable deductible shown in the declarations. Coverage is included for a loss caused by, but not limited to, the following: fire, explosion, or earthquake." The policy defined non-owned automobile as one, an automobile or trailer while being used by you or a relative with the owner's permission, which is not owned by, furnished to, or made available for regular use to you or any resident in your household, or to a commercially rented automobile or trailer used by you or a relative on a temporary basis. In granting a motion and the judgment in favor of Metropolitan, the Circuit Court reasoned as follows. On March 31, 2016, BGD Law, a law firm owned by Dusing, leased the 2016 Mercedes for a period of 5 years or 60,000 miles. That lease also provided a 24-month service agreement. The lease also charged BGD Law fees for license and registration of the vehicle. Dusing asserted that he is entitled to coverage for the loss of the Mercedes, claiming the vehicle was a non-owned vehicle under the policy. In response, Metropolitan took the position that the 2016 Mercedes could not qualify as a non-owned vehicle for several reasons, including: 1, the 2016 Mercedes was not provided on a temporary basis, but rather was the subject of a 5-year, 60,000-mile lease with a 24-month service agreement. 2, Metropolitan stated that the vehicle was not commercially rented. Unlike a rental agreement, the 2016 Mercedes was provided to BGD Law and charged license and registration fees, which are not standard for commercially rented vehicles. Having reviewed the evidence in the case, and having considered the briefs of the parties, the court agreed with the position taken by Metropolitan that the 2016 Mercedes was not a non-owned vehicle, which would allow it to be covered by the policy issued in 2015. In sum, there was no coverage for the loss to the vehicle under the Metropolitan policy. It was undisputed that Dusing failed to purchase insurance for the 2016 Mercedes. Therefore, it is not a covered vehicle pursuant to the policy, which, to be clear, is Dusing's personal policy. The Court of Appeal was logically inclined to agree with the Circuit Court that a vehicle subject to a 5-year lease cannot reasonably be considered as a non-owned vehicle for purposes of the policy. Indeed, it strained credulity to consider the 2016 Mercedes at issue in this lawsuit to be a commercially rented vehicle being used on a temporary basis, merely because it was being leased by Dusing's law firm. Therefore, it was unreasonable to conclude that Dusing had a reasonable expectation of coverage. In my opinion, this is an example of a lawyer attempting to force an insurer to pay for a loss he knew, or reasonably should have known, was not covered by his personal auto insurance. A car leased by his law firm and provided for his use is not a personal auto. Leased for 5 years could not be considered temporary under any concept of reason or timekeeping, and should have been insured by the law firm that leased it. Although Dusing had an insurable interest in the Mercedes, he failed to advise his insurer that it was leased for his use, nor did he pay premium for the policy. Taking the case up to the Court of Appeal was a waste of his time, the trial court's time, and the time of the Court of Appeal. This video was adapted from my blog, Zelma on Insurance, which is available to anyone free at zelma.com/blog. You can also subscribe to it at the blog post and or subscribe to Excellence in Claims Handling at locals.com or Excellence in Claims Handling at substack.com. If you found this video interesting or useful to you, please subscribe to the blog and please inform your colleagues and friends that it exists so that they can also subscribe and view these blog postings and videos. Thank you for your attention.